everyone. Welcome to the Billy Wilder Theater. Thank you. I'm Claudia Besser. I'm the Director of Public Programs here at the Hammer Museum, and it's my pleasure to welcome you all tonight. The Hammer Forum is a monthly series of discussions about current social and political issues, and it's made possible with the support of the Rosenbloom Family Foundation. And I also want to thank our co-presenter, the UCLA School of Law. 1 year ago, we had a Hammer Forum here in the Billy Wilder Theater called From November 5th to January 6th, Are We Ready for a Fair and Legitimate Presidential Election? It was also moderated by Rick Hasen, and it was just before the presidential election, and in it the panelists discussed whether or not we could expect the candidates to accept the presidential election results and have a peaceful transition of power. And I cannot believe that that was just 1 year ago. So much has happened since January 6th, and honestly, it feels like a century. So tonight we're going to have a conversation about how the Supreme Court is doing under the new administration. But first I want to read you a passage about the role of the Supreme Court that I just copied tonight from the official government website, uscourts.gov. It says, the Supreme Court plays a very important role in our constitutional system of government. First, as the highest court in the land, it is the court of last resort for those looking for justice. Second, due to its power of judicial review, it plays an essential role in ensuring that each branch of government recognizes the limits of its own power. Third, it protects civil rights and liberties by striking down laws that violate the Constitution. Finally, it sets appropriate limits on democratic government by ensuring that popular majorities cannot pass laws that harm and or take undue advantage of unpopular minorities. In essence, it serves to ensure that the changing views of a majority do not undermine the fundamental values common to all Americans, i.e., freedom of speech, freedom of religion, and due process of law. Our guest speaker tonight has written a new book that examines whether or not the current Supreme Court is in fact fulfilling those four fundamental roles. Tonight, Professor Leah Litman, co-host of the extremely popular and award-winning podcast Strict Scrutiny, which follows the workings of the Supreme Court, will discuss her provocative new book, Lawless, How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Litman is a professor of law at the University of Michigan Law School, where she teaches and writes on constitutional law, federal courts, and federal post-conviction review. Her research examines unidentified and implicit values that are used to structure the legal system, the federal courts, and the legal profession. Tonight, Professor Litman will be in dialogue with UCLA law professor Rick Hasen. Hasen is a professor of law and political science here at UCLA, and he's the director of UCLA Law's Safeguarding Democracy Project. His many books include Cheap Speech, Election Meltdown, and The Voting Wars. So after tonight's discussion and audience Q&A, we'll have a chance to continue the conversation over some light refreshments outside in the lobby, where Professor Litman will sign some copies of her new book. So I really want to thank you all for joining us tonight, and please join me in giving a warm welcome to Leah Litman and Rick Hasen.
Good evening, everybody. Good to be with you again. It's always a pleasure to be at the Hammer Museum, but I have to say this is a special pleasure because Leah and I were colleagues at UC Irvine when Leah was starting her teaching career, and I always knew she was going to be a huge star in both academia and the world, and I'm just thrilled to be with you here today. So thank you for making the trip to LA, even on a rainy day, and looking forward to our discussion.
Well, thank you so much for having me. I am delighted to be here. I have very fond memories of our time together in Southern California, although it really does feel like a lifetime ago, even though it was just 8 years.
So this is the book, Lawless, and I have to say that I enjoyed it a lot, but I think it was not written for me. When I read your law review articles, they're going into the anti-terrorism and
Effective Death Penalty Act.
Right, and various rules on habeas corpus. Those articles typically do not cite to Mean Girls,
No.
Or to Arrested Development.
Nope.
So tell us a little bit about why you wrote this book, who it's for, and what you're trying to do.
So I wrote the book for an audience that I would kind of define as, people who are interested in and following what is happening in our politics, but aren't up close and personally observing the Supreme Court. That audience might include lawyers, it might include non-lawyers, but it is people who are interested in and want to know more about what the Supreme Court is doing and how the Supreme Court came to be functioning the way it is. As to why I wanted to write the project, it emerged out of a few different things that were happening. One of them was the podcast. As the podcast was taking off, it just became apparent that there was a real desire for people to learn more about the Supreme Court, which is a notoriously non-transparent institution that is a little bit difficult to follow the inner workings of, if you don't follow it day in and day out, and if you haven't done a lot of background reading on the law and politics. So it was designed as kind of an effort to democratize information about the Supreme Court and to do more than I can do on the podcast, which is just following what the court is doing, in a given week. And I think doing it in a written form, makes it easier to see some connections when you can see the similarities in the arguments that were being made in politics 50 years ago to the opinions that the justices are writing today. So it emerged from, a variety of projects where it just became apparent that people wanted to know more and understand more about the Supreme Court.
And just to briefly follow up on that, do you think that there's more interest in the Supreme Court now because of what it's doing? Is there more interest maybe because of social media makes every institution more accessible and susceptible to critique? Or what do you think is driving this?
I think it is a combination of different factors. I think one of them is the court, for a variety of reasons, has just become a more partisan institution than it was 50 years ago. And I think some people were taken by surprise when the court overruled Roe versus Wade. And so I think some decisions of the court, as well as patterns in their decision-making, have spurred more interest in the court because the court seems to be acting in different ways than people learn about, in high school or middle school when they are told, the Supreme Court functions as a check on the other branches of government and stands up for the rights of unpopular minorities. It doesn't always look like the court is doing that today.
Yeah, I mean, when we were backstage and heard Claudia read how the U.S. Courts.gov, the official website of the U.S. Courts, describes the Supreme Court, it's a certain kind of ideal, but not necessarily what we're seeing right now. Which brings me to the subtitle of your book. So your book is called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. Maybe let's start with vibes.
Okay.
What do you mean by that? And what are you trying to say in that subtitle?
Yeah, so this was something, honestly, I can't remember the first time I used it as a punchline in describing something the Supreme Court had done, but it just started as a joke where I would say it was no law, just vibes, no facts, just vibes. And so what the phrase is designed to capture is to draw a pretty pointed contrast between what the court is doing and what most people think of as the law, something that is objective, determinate, things that we would all read and look at the words on the page and come to an understanding this is the right answer. And instead, vibes are way more subjective. They might be drawn in part from someone's innermost feelings, like their perceptions of the world, their perceptions of reality. It might be drawn from the zeitgeist of the milieu in which they are just part of, whether that's a political party, whether that's a social movement, whether that is the segment of culture they are a part of. And so it's just meant to draw a contrast between something that is objective and determinate and something that is a little bit more loosey-goosey.
All right, so let's talk about that in the context of some of the subjects that you talk about in the book. So maybe we can start with reproductive rights and LGBT rights, which comes early in your book. What has the court done, and why do you think that would fairly be called lawless?
Sure. So I'll take one clear example that actually came up in a case that was argued last week at the Supreme Court. And the case that was referenced, or the case that was argued last week, involves a challenge to a ban on conversion therapy. And that challenge is premised on the idea that it is a violation of the First Amendment for a state to prohibit licensed therapists from conducting conversion therapy. And the Supreme Court had decided a previous case.
Can you just define conversion
Oh, I'm
therapy?
sorry. Yeah. So conversion therapy is the kind of therapy whereby, a therapist attempts to change the behavior of their patient. So if you come in and you say, I'm gay, the therapist tries to tell you, no, you are actually straight and you are attracted to people of, the opposite sex or a different sex. So that's what conversion therapy is. And a state has tried to prohibit licensed therapists from practicing it because it is harmful, it is not consistent with, accepted professional standards of care and other reasons. So 5 years ago, the Supreme Court had a case, NIFLA versus Becerra, which involved a challenge to two California laws. And they were regulations of crisis pregnancy centers, which are organizations that, market themselves as offering various forms of reproductive health care services, but they don't actually provide the full complement of reproductive health care services, specifically abortion or access to contraception, and instead try to counsel patients out of it and, mislead them and potentially delay their ability to receive that care. And California required unlicensed crisis pregnancy centers to disclose the fact that they were unlicensed. That is a very real objective fact about the world. And states have, or at least had, considerable latitude to regulate professions and regulate professional standards of care. They can tell lawyers, you can't steal from your clients and you have to abide by various standards. They can tell doctors, you can't do X, Y, or Z in treating your patients. And California tried to do that again with crisis pregnancy centers. And the Supreme Court said you can't require them to disclose this objective fact. Why? Because it concerned abortion, which the court described as anything but an uncontroversial topic. So that is an instance where the court literally said, we're not going to apply our usual First Amendment rules, like the law. The rules, the doctrine just doesn't apply. Why? Because this topic is not uncontroversial, people have big feelings about it. So that's an instance where the courts seem to be fashioning the law and making an exception to the law based on, strongly held views about a topic. And now that case, that principle is being imported into the law of LGBT equality, in the case involving the challenge to the ban on conversion therapy. So that's just one instance, but I think there are many occasions where they are drawing from strongly held views, perceptions of reality, and feelings in order to give content to the law and create exceptions to the law.
So let's contrast the current court with the Warren Court. The Warren Court, a very liberal court, came up with a lot of decisions that people would recognize today. Miranda versus Arizona, Mapp versus Ohio, lots of cases in my area of election law, the one-person, one-vote cases. The one-person, one-vote cases changed earlier precedent, which said these cases can't be heard by courts. They're non-justiciable. So was the Warren Court running on vibes, and are they just vibes that you like more, and it's all vibes? Or is there law, and we can tell when there's vibing going on versus law making or law interpreting?
Yeah. So a professor at Harvard, Richard Ray, is authoring this year's Forward to the Harvard Law Review. And, the title of it is A Conservative Warren Court. And he basically makes the claim that the Roberts Court is, the equivalent of the conservative Warren Court. And I think, people have drawn this analogy between, the Roberts Court is overruling precedent and refashioning law, so too did the Warren Court. So, what's good for the goose is good for the gander, I guess. And I think there are some superficial similarities, and parallels you can draw. But I also think there are important differences. And some of them I will acknowledge, is because I think the Warren Court was fashioning the law based on principles that are integral and essential to a liberal constitutional democracy and a multiracial democracy. And maybe you consider those substantive. I guess I don't really care whether they're labeled substantive or not, because I think they are at bottom. If we want to be a country that has the rule of law and multiracial democracy, we need a representative political system where elections actually reflect, voters' input, like the one person, one vote line of cases. We can't have a system where politicians get to write the rules in order to entrench their own power, notwithstanding the will of the voters. So yes, right, some of it is substantive in that the Warren Court was guided by principles that I think have to be the basis for a liberal constitutional multiracial democracy. Sorry.
No, go ahead.
But I also think there is some separation between law and vibes. And so I think there are going to be some areas of law where it is difficult to separate them, where the justices are inevitably drawing on their own views about what constitutes equality or liberty. These aren't self-defining terms. So of course, someone's life experience and their own view about what makes for a sensible way of structuring government is going to inform how they interpret those words, where there just isn't much to go on, and how they interpret conflicting historical evidence. But there's also cases where the law is just clear and you can't get around that. And yet I think the Roberts Court does that in ways that are so transparent that they are departing from any, I think, coherent definition of what law is. I think the Shelby County case, Shelby County versus Holder from 2013, where the court invalidated a key provision of the Voting Rights Act, the preclearance process that had required certain states to obtain the federal government's permission before changing their voting laws and policies, is an example of one such case. And I would take up the entire time if I tried to explain why that is, but I'll just give you two examples. One, Roberts had to insert an ellipsis into a quote from a prior case in order to change its meaning to support the principle that he just drew out of thin air. Second, he invented this principle that Congress, generally cannot distinguish between the states, which is nonsensical, especially when you're talking about voting rights legislation, when the Union, the Reconstructionist Congress only allowed the Confederate states back in the Union by subjecting them to a set of rules that other states weren't subject to. So the entire theory had no basis in the constitutional text and precedent in history, and Roberts just, plops it onto a page and uses that to strike down, the crown jewel of the civil rights movement.
So let me give you another example from the Warren Court era, which is a case called Harper versus Virginia State of Elections. So this was the first case where the Supreme Court struck down poll taxes. The court had said you couldn't have a poll tax that was administered in a racially discriminatory way, but that even fairly applied poll taxes. And I was always struck by a line in Justice Douglas's opinion. The dissenters had said this is not in line with the original understanding of the Equal Protection Clause, which was not seen as applying to political rights. It was seen as applying to what they called civil rights.
Yeah.
And Douglas's, and this is all politics, was what the dissenters said. And Douglas's response was, this isn't what we think is right. It's what the Equal Protection Clause requires. So is that just an example of vibes? Is that living constitutionalism? And what should, if you were, if you were looking for justices to go on the Supreme Court, what is the standard that they should be using to be making determinations like this?
Yeah. So the Harper example, I think I would probably put that into the category of more living constitutionalism or evolving constitutionalism, where it's true that at the time the Equal Protection Clause was ratified, there were understandings thinks that there were separate categories of rights, like social rights, political rights, economic rights, and that some people use that framework in order to allow states to create, separate but equal segregation. That was partially the basis of Plessy versus Ferguson. The case that allowed states to have separate but equal segregation on the ground that while the Equal Protection Clause really just applies to certain political rights, not to social rights, it doesn't guarantee social equality. Well, that framework, I think subsequent generations came to see, entrenched and reified a racial hierarchy that is inconsistent with basic principles and conceptions of equality and multiracial democracy that I do think are embodied in the Equal Protection Clause and the project of Reconstruction, that reshaped the country and reshaped the Constitution. So I think I would probably categorize that as, an example of seeing how this framework, that some people use to narrow the scope of the Reconstruction Amendments, basically proved it undermined the entire project and couldn't be enforced in a coherent way that could be reconciled with the underlying principle of the Reconstruction Amendments and, particularly the Equal Protection Clause. As to what I would ask a justice, I'm not sure I have a particular set of questions, but I guess the traits that I would be looking for would be something like humility, careful study, and a willingness to consider all available evidence. I think we right now are giving a preference to and a leg up to justices who have these magic formulations that sound nice and that they sound like, okay, here's my simple, easy rule that is going to generate right answers and mean I never have to consult anything approaching, values or substance or, my perceptions of the current world. And that's just not the way law works, especially in hard cases. So someone who recognizes that, acknowledges it, and says, I'm still going to do my best and consider perspectives that, might not be my first intuition, those are among the traits that I would be interested in.
So if we're thinking about the current Supreme Court, one way we might divide them roughly is originalists and living constitutionalists, although I don't know that all the conservative justices would call themselves originalists. I don't think Roberts necessarily would use that term.
I mean, Sam Alito has mocked it
right.
in oral arguments.
He has mocked it and then used it.
Yes.
But one way we might divide them is they have bona fide jurisprudential disagreements about methodologies. How should judges do their job? Another way we might divide them is, say, the Republican justices and the Democratic justices, because for the first time in modern history, all the conservatives on the court have been appointed by Republican presidents, all the liberals by Democratic presidents. It wasn't always that way. Justice Stevens, who in his later years was more liberal, Justice Souter, they were Republican appointees. Justice White was an appointee of President Kennedy, conservative on at least some issues. I know that Justice Barrett, after she was confirmed, she was giving a speech, ironically, at the McConnell Center, and she said, "We are not partisan hacks." And I thought this was not the right location to be made. This is after, of course, she was rammed through, was it a week before the election?
Yeah.
How much of this is raw, naked partisanship versus jurisprudential, good faith disagreement?
Yeah. So I guess what I would say is in the book, I kind of bracket that as not the right question because on some level, it doesn't ultimately matter whether the justices are looking at these cases and saying, I am trying to do what my partisan priors suggest I want to do versus I am applying a methodology that just so happens to allow me to reach results that cohere with my worldview. Because either way, the people who are picking the justices can pick people who they can reliably predict will rule in ways that, advance the partisan political ideological project. And so whether or not the justices are, deciding cases based on partisan priors or based on these jurisprudential commitments that just so happen to track, ideology and politics doesn't really change how the court is kind of being used today by elected politicians. But I think the ultimate answer is probably it depends which justice we're talking about. And I also think it is just easier to select a jurisprudential method that is associated with a view of the world and an ideology that you are sympathetic to, because justices are inevitably like checking, okay, does my interpretive methodology work? Right? Is it generating results that I think like are the right answer for how our Constitution is set up? And those right answers are going to seem more right to you if they kind of reflect what you think is a sensible way of structuring government.
I think that some of the justices draw on, whether consciously or not, their political experience.
Yes.
Chief Justice Roberts was a staffer in the Reagan administration, DOJ. Kavanaugh worked for Bush. Kagan worked for Clinton. Do you think that's a detriment or something to their credit that they kind of understand how, as opposed to like appointing the law professor who's never done anything real like that?
Podcasting is very real. Podcasters are getting great jobs these days. I think that having experience in other branches is good. I wish that there was a more diverse array of experiences at the Supreme Court, because right now you have a lot of people, who worked in the executive branch in some ways or worked in DOJ. We don't have people who worked in the state court system. We don't really have people with extensive legislative experience. We don't have people, who worked in other capacities. So, I think that their prior experience definitely does, shade their views about the world. I mean, Justice Thomas, famously makes jokes about, well, when I was at the EEOC, kind of like, here's how, we did things. And now, those determinations are getting deference. And so he draws on his experience there. You also have, the justices drawing on their prior experience in the executive branch. I think it's no accident that, Justice Kavanaugh is one of the justices with a more expansive views of presidential power and executive power, right? And he worked in the executive branch, and so I think it's good for the justices to have some prior experience. I think it's bad that the experiences they right now have are so limited and so similar to one another.
I want to get back to executive power and what's happening now. We will get there, but I want to talk more first about the book. So one way of describing the conservative justices is originalists, at least some of them. Another way is Republican appointed. Another way, as you do in the book, is the five guys and Amy. And so I want to ask you, your book is very cheeky. It's very entertaining. But I wonder if there's a downside in presenting the court like this. And I want to read you a quote from a friend of mine, Bob Bauer, who is former White House counsel for Obama, who was Joe Biden's lawyer. And he recently wrote about legal commentators like us. He said, "The challenge for the community of legal commentators is to present strong, well-reasoned positions while making their case to the broadest possible audience, in constant dialogue with those who disagree with them. An obstacle to success in this endeavor is denial or fudging of the complexity of difficult issues, the suggestion that there's one clear good faith answer." Do you worry about how you're talking about the court affects the legitimacy of the court or affects your ability to influence outcomes? I mean, it's great to have a cheering section at, when you do a live version of your podcast, but there are going to be lots of people who'd be booing you loudly, except they're not in the room.
Yeah, so I think that everyone is going to make a different calculus about where to draw the line. And I just so happen to think that, one of the more important functions that people with legal training and a background in law have right now is to speak to the public about what the law is, how it's working, what the Supreme Court is doing with it, and what the executive branch is doing with it, what Congress is doing. And so in that vein, I am not speaking in an academic tone in a way that I would in a faculty workshop or in a law review article, because no one reads law review articles, except for us. I know, I hate to tell you. And so I think in order to reach a broader audience, I want to use more conversational tone. That's not going to include, some of the language that I would use in law review articles. But also, part of the cheekiness of the book is because, a lot of different reasons. One is the story I tell is not a happy story about the Supreme Court. And I wanted to tell it in a way that didn't make people want to check out and just give up, and instead wanted them to feel empowered and invested, like they could fight back. And that's part of where the pop culture references and snark comes from, in order to make it like more digestible. And, you can actually make it through the end. So it's like a LOL sob, like laugh while you cry kind of energy. I have no doubt that like some people, right, who don't agree with me, like honestly, probably anyone who disagrees with me, like they're not going to love this book, but that's not who I wrote it for. I wrote this book for, again, people who are concerned with what is happening with our country right now. I want them to understand how the Supreme Court is part of that story, because when like we get out of this and emerge on the other side, I think we have to have conversations about what to do with our institutions to ensure we don't revert back to this and don't find ourselves in this situation again. And I think the Supreme Court has to be part of those conversations. And so that's, kind of the group that I wrote this for. Anyways, there's more I can say, but basically, I don't think my job is to protect the Supreme Court's legitimacy if they're not earning it. Like, my job is to say, here's what they're doing and to defend that. And, I think I have I have a lot of footnotes in the book, and, I'm happy to defend my arguments about them.
If I could push a little bit further on this. So yesterday at UCLA, you gave a faculty workshop where you talked about let me get the term right, legalistic noncompliance, where the Trump administration is not following what courts say, but they pretend that they're following what courts say, and you nicely catalog the different devices by which they've done that. Is it possible that now that, everybody's got a social media account or 10 social media accounts and everybody can criticize everything immediately, that we've taken the justices not down one notch but down 10 notches, and everybody is treating them as though they're politicians in robes? And so then when you actually need the court to stand up and say, okay, turn the planes around, that now it's gone.
Yeah, so I guess I don't think that keeping the court's legitimacy above a certain level, is going to get them, to actually enforce, the Equal Protection Clause, or get them to recognize that Congress has the authority to enact legislation under the Reconstruction Amendments. Because, 12 years ago, the Supreme Court was probably the most highly regarded of the three branches. That was the time when they were beginning the rampage on campaign finance legislation. That was the time when they were, dismantling the pre-clearance process. And so I think even when their approval ratings are good, I think that can enable them, to get away with a lot of, their agenda that is unpopular, not based in law, and that people would push back on, if they were more fully informed about what the court is doing. So I think if the goal is, to get the court to actually uphold the rule of law, I think it is unclear whether kind of bolstering their credentials or taking them down a notch, is the way to do that. And, my, again, goal is to say, here's what the court is doing, and to defend kind of that vision and to give people my assessment and a picture of what I think the court is doing. I think that challenging the court publicly, that is a way to actually get the court to uphold the rule of law. If you think back to 2 years ago, that is when the court was hearing the precursor to the current challenge to what remains of the Voting Rights Act, Section 2. This was a case out of Alabama. And in that case, they kind of held their fire and opted not to, strike down the other key provision of the Voting Rights Act. And I just don't think that was an accident, that happened the year after they overruled Roe, their public approval ratings plummeted, and the midterm elections were much more favorable to the Democratic Party than people expected, because they looked around and they saw we are facing meaningful political pushback and public opinion fallout. And I think that is a way of ensuring that the court is more mindful of a broader set of perspectives and where the median views of the country are, than just telling them, you're doing amazing, sweetie, please do the right thing.
So it is true that back in the Allen versus Milligan case, the Alabama case, 2 conservative justices joined with the 3 liberals in holding fire. 4 justices were willing to call Section 2 unconstitutional or read it in a way that it would be denuded of power. But Justice Kavanaugh, one of the conservatives in the majority, went out of his way to say, hey, Alabama didn't raise this argument about why the Voting Rights Act may be unconstitutional, but the door is open, and now today is October 14th. Tomorrow, October 15th, there will be an oral argument in a case out of Louisiana called Louisiana versus Calais, where, at least by my read, based on the Supreme Court asking for additional briefing over the summer, releasing their order 5 p.m. on a Friday in August, putting the Voting Rights Act Section 2 up for grabs. So maybe it was just John Roberts again playing the long game, as he did before there was Shelby County. There was a case 4 years earlier where the court said, hey, we might strike down the Voting Rights Act. So maybe all it did was just buy a little bit of time.
Yeah. No, I mean, I think that is right. And I think that is partially why I don't think an answer to the Supreme Court is just saying, well, have people focus for all time, all of their energy or enough on their energy on the Supreme Court such that the court avoids, doing these things that are, so staggeringly consequential and damaging to our democracy, as invalidating, the key provision of the Voting Rights Act. I don't think that is like a sustainable reform or, solution to the Supreme Court. I think like more meaningful institutional reform is probably necessary.
I want to come to that, and I want to think back to, you can go back to the 1960s, 1970s, impeach Earl Warren bumper stickers. For a generation, or more than a generation, Republican presidential candidates ran against the Supreme Court, even when the court had turned sharply to the right. Yep. There was a very potent issue, and it was much more, what I remember in 2016, that was the Hillary Clinton, Donald Trump race. Mm-hmm. People who thought that the court was important were much more likely to turn out to vote for Trump.
Yep.
So now I think things have reversed, and I'm just wondering what do you think should be the platform of Democrats who might want to oppose the court? Is it, I don't like the term court packing, but is it Supreme Court reform? Is it term limits for justices? Is it adding justices? What does it look like to talk about if we get through these next few years, what our democracy might be?
Yeah, so I am unsure actually whether we have reached a point where if you asked voters, do you care about the Supreme Court, if you would actually see, more people who lean left indicating that question versus more people who lean right, just because I think even though the Supreme Court has taken on more salience, right, and more people on the left are aware, that the court and the courts are an issue, I'm not sure we have quite reached parity, just because the Republican Party has been engaged in a decades-long project of talking to their voters about the courts. And I think they have built up a kind of like voter education and like public education framework in a way that the left just hasn't yet. And so I still think like more work has to be done in kind of getting, people, leaders on the left to actually talk to voters about the court in ways that underscore the importance of the court. And so to that end, I'm not sure that running on a platform of Supreme Court reform, right, is the best thing, for people on the left to do. I'm not a political strategist, but like my intuition is, talk to people about the issues that they care the most about. And for many people on the left, that's going to be some combination of climate change, economic inequality, political corruption, multiracial democracy, LGBT equality, reproductive rights and justice. And you can ask them, imagine, like, just tell me the federal law that you want Congress, to enact in order to address that problem. Is it a restriction on partisan gerrymandering? Is it a restriction on dark money in politics? Is it federal protections for abortion? Because any of those laws, right? Like, I am not confident that they would withstand the current Supreme Court. And so if you care about those issues and you want Congress to be able to solve them, then you should also care about giving more power to the institution, that is more directly accountable to and responsive to people.
I think your point about salience is a really important one. I recently wrote about this voting rights case being argued tomorrow, that when Donald Trump damages democracy, it looks like a car wreck and everybody's paying attention. But when the Supreme Court does it, it's more like a slow poisoning.
Yeah.
Or you gave the example of the boiling frog yesterday in your talk. The court speaks in opaque language. It issues,
if it speaks at all.
Yes. Well, we'll get to that. It issues written opinions sometimes that are very turgid, and even the clearest writers on the court, I would say that's Roberts and Kagan. It's not beach reading. So I mean, part of it is the nature of the beast.
Yeah.
It's just hard to explain to people, and you throw around terms like the specific terms in the Constitution. You talk about substantive due process, people's eyes will glaze over. So I do think there is something to that. But I think now the Supreme Court is in the public eye in a way that it wasn't before, because everybody's been looking for checks on Donald Trump's power. So I want to turn there. I have a series of questions on that, and then I'm going to turn to audience questions. So first of all, are you surprised by what's happened with how the Supreme Court has interacted with Trump 2? If so, how, and what are you seeing?
No. So the book came out in May, and May was basically before the Trump administration started down this 20-plus case winning streak at the Supreme Court on the shadow docket, where the Supreme Court basically gave the Trump administration the requested relief, freeing them from their obligations to comply with lower court decisions that had invalidated various policies. So when the book was coming out, that was during the very initial days where there were actually 2 cases where the court had ruled against the Trump administration, or seemingly so, although I tried to tell people it looked more significant than they were, and I was proved right. But so I got this question of like, okay, well, isn't the court good now? And shouldn't we expect the court to rule against Trump? And my response was no. You have a majority of the court who actually embraces the theory of executive power that is driving, a lot of the more abusive exercises of authority that the administration is engaged in. So even putting aside questions of partisanship, like, this is a court that is on board with the ideological view of the expansive powers that the executive branch should have, and giving the president that degree of control over the federal government. So I did not expect them to really be a meaningful check on the president that, again, was definitely going to break legal constraints, on president's power that have been respected, for decades, if not longer. I did wonder whether they would kind of look for more freebies, and whether, the Chief Justice in particular would want to find more cases where he could rule, against the Trump administration in order to preserve like some superficial appearance of, neutrality or institutional legitimacy. I didn't expect them to be very many or that meaningful. I kind of expected more than like 2. Which is kind of where we are right now. But no, like, I wasn't surprised, just given, the observations, that went into the book, and also just knowing kind of many of the justices' views about executive power in particular.
So it's like, no one ever asked us before if the president could fire someone in the Federal Reserve. Thanks for asking.
Well, no one ever asked us whether the president could decline to spend funds that Congress had appropriated, or whether the president has the power of the purse, as well, and hey, this is a novel question, so here's our answer.
So let's talk, first, before we go to some of the specific cases that are coming before the court and have been, you mentioned shadow docket. Just explain what that is, and why why is when the court decides something on the shadow docket, it qualitatively different from its normal course of things?
So the shadow docket refers to the set of decisions that the court makes without the benefit of full briefing, oral argument, and sometimes without a written opinion or reasoned set of explanations at all. The shadow docket runs from totally mundane requests like, can the Solicitor General of the United States, who represents the federal government, participate in the oral argument in order to give the federal government's views, to requests for emergency or extraordinary relief, where in particular the federal government goes up to the Supreme Court, asks for what's called a stay, which is just an order putting on hold a lower court decision. And the effect of that stay is to allow the administration to implement a policy that has been declared illegal by a lower court while that litigation remains ongoing. So the shadow docket is different in part because, it doesn't have the full set of information that goes into, the cases that the court hears on the regular docket. It also happens on a schedule that is way less predictable because they don't hear oral arguments, because their decisions aren't released, on full opinions. They don't announce decision days in advance. So a lot of these orders have come, Friday night at like 5 p.m. And so, yeah, it's just more unstructured, more preliminary, and it's unclear exactly like what force the Supreme Court thinks its orders or decisions on the shadow docket have.
And that's caused some problems for some lower court judges. So there's a Supreme Court precedent that says president can't fire certain independent agency heads, and Trump fires them. And the Supreme Court has said, no, we're staying the lower court order that reinstated the person. We're not going to tell you why. And then the lower court follows the precedent of Humphrey's executor, and then they get smacked down. And then Justices Gorsuch and Kavanaugh wrote and said, hey, why aren't you listening to us? To which one federal court judge, I think it was in the Harvard case, said, you're not being the models of clarity here. It's like, are we supposed to pick up your vibes? I mean, it really did feel like that. Is it about vibes, or are we supposed to follow precedent?
Yeah, and I think many judges have expressed their frustrations at what the Supreme Court is doing. Some of them in opinions, like in the Harvard case, as you note. Some actually speaking to journalists, which is really an indication of how frustrated the lower federal courts are with what the Supreme Court is doing. Because the idea that federal judges are talking to the press and complaining to them about what the Supreme Court is doing, and they have described this as like a war zone as far as the Supreme Court's treatment of the lower federal courts. They have even said like somebody is going to get killed, insinuating that the court is basically fanning the flames of the administration's war on the legitimacy of lower federal courts actually reviewing the legality and lawfulness of the executive branch's actions. So the frustrations with the Supreme Court, I think, extend very far.
So Justice Amy Coney Barrett, like you, has a new book, and she's also touring like you. And she was asked, why doesn't the Supreme Court give like a couple of sentences of an answer, an explanation for why it's issuing these rulings on the shadow docket? And she basically said, we don't want to lock ourselves in. We don't want to prejudge the case, even though these rulings might last for half of the Trump term or something like that. But then, so I didn't think much of that argument, but then I read the shadow docket order in the Nome case. This is the case involving right here in Los Angeles County, whether ICE agents can stop someone for essentially speaking Spanish and looking Latino. And the court didn't explain why they put the ruling on hold that was stopping ICE from doing this, but Justice Kavanaugh decided to weigh in on his own, and he basically said, yeah, that should be enough, and he's been roasted. And they talk about when a U.S. citizen is being held for days, they're calling it a Kavanaugh stop now, because he said, it's just a minor, they check your papers and you're free to go, as though people should be walking around with their citizenship papers in their pocket at all times.
Yeah, and so I kind of think he should be pilloried, right? He should be roasted, right? If that was the basis for him, staying the lower court opinion, on the basis of this account of what is happening that is untethered to reality, completely not rooted in any of the facts. The district court in this case issued a 50-plus page opinion. The Ninth Circuit also issued, a 50-some page opinion that is based on actual facts that were presented to the court. And instead, he just kind of invents this narrative that is just completely divorced from reality. And so I kind of think he's getting criticized. He should be criticized, and the court should be forced to explain its decisions so that they can be subject to some public evaluation and accountability, because that's partially what makes, the federal courts and the Supreme Court different. They provide reasons for their decisions. When congressional representatives vote for legislation, they don't necessarily have to lay out, here's why I voted yes, here's why I voted no, and then they bind themselves to that reasoning in future cases. That's what courts are supposed to do. That is their measure of accountability, because we don't, decide whether they are reappointed in elections. And so their accountability comes in actually giving reasons, that people can read and weigh in on. And the fact that they have just removed that measure of accountability because it is inconvenient, too hard, or they don't want to be subject to that kind of accountability is just not a good enough reason. And also Barrett's reasons, we don't want to lock ourselves in. Are you serious? I mean, come on. You are simultaneously criticizing lower federal courts for not following these decisions that aren't locked in and aren't supposed to lock you in. Both of these things cannot be true. Second is all of the lower federal courts' determinations in these cases are preliminary. They're all arising in the context of preliminary injunctions or stays. Yet the Court of Appeals, they manage, to put together an opinion, even though that is their tentative and preliminary views about the case, and even though they have to get consent from their colleagues, right? Those are also panels of several judges. So they managed to do it. You can and should too.
The other thing that Kavanaugh said, not in that particular case, but recently, is that there's 4 factors that are typically considered. How likely is it that the one side's going to win or not? Is the plaintiff going to suffer harm? How do you balance that harm against the harm to the government and then the public interest? And he basically said in all of these super important cases, everything is there's important interests on both sides. So it really comes down to our guess about the merits. And so if that's true, then it seems like they're sending big signals.
Oh.
So let's take some specifics. Everybody can be fired except for someone on the Federal Reserve.
Maybe.
Because there's a Federal Reserve exception to the... So what is that all about?
What is that all about? Well, it's partially about their investment accounts, since, giving the president, the authority to exercise, political control over the Federal Reserve Board has the potential to crash the United States and global economy. But, what is this about? That Kavanaugh statement was super revealing to me, because on one hand, that is inconsistent with what Justice Barrett is saying on her book tour. He's saying the court is signaling what they think about the merits. And if they're signaling what they think about the merits, do they expect lower federal courts not to follow that? Again, it's difficult to hold both views. Second is he is admitting that they are applying a different standard for cases involving the Trump administration than other kinds of cases. Because what he's saying is, in cases involving the executive branch, it all comes down to whether we think the party is likely to succeed on the merits. Whereas in these other cases, well, then we will consider, where the likelihood of irreparable injury, lies, where the public interest lies. And so he's also admitting they are just applying a different set of rules, in cases where the federal government, the Trump administration, is asking, for some form of emergency relief, on the shadow docket. So I just think the shadow docket has been so revealing, because it is asking the court to act more expeditiously. And when they do so, the partisan divides are even more apparent, than they are on the regular docket and the merits docket. And Adam Liptak wrote a recent story about this in the New York Times. And he said, it's not just that it's the shadow docket versus the merits docket. It's that the court's treatment of the Trump administration on the shadow docket is vastly different than their treatment of the Biden administration on the shadow docket. I mean, Justice Alito is granting, I think it was something like 90% of the cases where the Trump administration is asking for relief, less than 30% of cases where the Biden administration was asking for relief. And I guess you could have the view that I guess the Biden administration was engaged in way more violations of the law than the Trump administration. You could have that view.
He did
I'm not
try
sure
to make
you
people
should
get
have
COVID
that view.
vaccines.
Right, exactly. He also tried to relieve student debt, but that's it's I guess the definition of tyranny these days. But yeah, I just think the shadow docket has been very revealing about where the justices' intuitions lie and like their instincts that again are going to be informing their judgment in all cases. To what extent is unclear.
Now, these shadow docket cases are coming back. They may take years because they go through the normal appellate process. They're put on hold in the meantime by the Supreme Court's order, but things are still happening in the lower courts. So at some point in the not-too-distant future, we're going to have merits decisions on birthright citizenship. Mm-hmm. And I'm imagining, it hasn't started yet, is going to be about National Guard troops in American cities. And so before I turn it over to the audience, cheer us up and tell us how these cases are going to ultimately come out.
My guess is they invalidate the birthright citizenship executive order. I don't think it's unanimous. And I think that is the real mark of how radical the court has become. The fact that, the birthright citizenship executive order just would not be summarily and unanimously invalidated.
Well, there is recent scholarship. The scholarship that's been written since the litigation has started that is now cited by the Solicitor General in his brief.
Exactly. How very convenient. The National Guard cases I'm extremely worried about. I just think these are some of the more chilling exercises of the federal government's authority. They are obviously based on pretext, not rooted in reality or good faith. They have huge potential for abuse beyond what is already happening. And I am very worried, given this court's views about executive power and their unwillingness to second-guess presidential determinations, especially Republican presidents' determinations. I'm worried about how those cases will go at the Supreme Court.
All right, we're going to turn it to the audience for some questions. I have two requests. First, keep it brief because there's other people who'd like to ask a question, and please keep it a question. And there are people going around with microphones. We can't see any of you. We just see very bright lights. So we're going to leave it to the people who are working up and down the rows to find people to ask questions.
All right. Thank you. This has been super fun. My really quick question is just why.
You have an interesting definition of fun, but yeah, go ahead.
Oh, no, this is great. Just basically like why. This is like something we haven't really talked about. As I'm wondering like why have the justices started to act this way? Is there a point in time in which they started, or has it been the entire tenure of the current justices, et cetera?
Yeah, so I think it is like a combination of reasons that have kind of pushed us to this reality. One is the rise in partisan polarization just made it easier to select justices where you could more reliably predict that their legal decisions would reflect, the views of the party that appointed them. And so I think that is one contributing factor. I think another factor is, the judicial selection machine and the right-wing legal movement, invested in this decades-long project of convincing their voters about the importance of the courts and investing in a machine to actually identify those individuals whose views they could predict, once they were appointed, and developing a system to basically, as one of the founders of the Federalist Society said to an author of the book about the Federalist Society, this is Amanda Hollis-Brusky's book, Idea with Consequences, one point of the Federalist Society was to keep the justices in check. And so I think it is the creation of that system, rise of partisan polarization and the modern Republican Party's like willingness to embrace a system of minority rule that has kind of contributed to how the justices are functioning today, and specifically like a more reliable partisan breakdown in their votes in these big ticket, high profile cases.
Is this, oh, okay. Thank you both so much. I have been really upset about this shadow docket business, and I'm wondering, what do we as citizens, do we have any control, or is it that we have to do whatever, just vote, Trump out and the right people in, enlarge the court? What do we do about this? This is really scary and bad. Thank you.
Yeah. So I don't want to just limit the solution to vote Trump out and like vote, the people who will do something about it in, because as Rick and I were discussing earlier, I don't think the Supreme Court, including the shadow docket, has the kind of salience right now that in the next election, even if a majority of Democrats, are elected in the House and the Senate and a Democrat is in the White House, that, shadow docket reform is going to be high on the agenda. And so I think that this is a longer term project that begins with public education and organizing, talking to more people about the shadow docket, participating, in town halls, nomination meetings, endorsement meetings, asking candidates for state, local, and federal office, what do you think about the Constitution? What do you think about the court's role, in our democracy? And like, what do you think you should do about that? And I think that building, that movement, creating incentives for elected leaders to actually do something to rein in, the abuses of the shadow docket, I think that is probably, a solution. It is a frustrating one because it's one that is difficult to kind of measure progress toward that solution, in kind of more shorter time periods. But yeah, that's kind of what I would say.
Given the court and the executive branch dealing with congressional actions, the statutes that talk about firing and so forth, as we've looked at the current situation, do you think Congress even has the power to correct any of that, to enact statutes that allow them to keep the power that they seem to have had?
Yeah, so I think Congress has, a substantial amount of power over the Supreme Court. They have power over the court's appellate jurisdiction. They also have the power of the purse. They can choose, what money goes to the court and for what purposes. It was Congress that passed the law, that made the current Supreme Court building. Congress can decide, whether and how many law clerks, justices get to have. They can try to call justices, before hearings. I think Congress has kind of lost the muscle memory for how to exercise oversight over the Supreme Court and how to, exercise the kind of political control that the Constitution contemplates they would have over the Supreme Court. And that is, one of the contributing factors to how we got to a system where the court kind of feels like they aren't subject to meaningful political checks. I'm not sure if that exactly answers the question, but, I think Congress can actually return itself to a position where it gets to, exercise the constitutional powers that it has.
If I could just briefly follow up, there's a chance that Democrats retake control of the House, and that's not at all certain, and especially with the redistricting that may be coming. Yeah. What do you think a Democratic House could be doing if there's still a Republican Senate and a Republican president?
Hearings and oversight. I think For example, some of the Democratic members of Congress are having these shadow hearings where they actually document the human consequences of some of the administration's actions. I think oversight hearings into the consequences of some of the Supreme Court's decisions would also be a welcome form of oversight. So talking about, these Kavanaugh stops, having hearings, where you hear from people who have been swept up in these ICE roving patrols, or you hear from the institutions whose medical research grants, have been cut off, and the kind of medical research, that we are not now doing because the Supreme Court allowed the administration to withhold almost $1 billion, in National Institutes of Health grants. You hear from federal workers, that were displaced and laid off, in the thousands because the Supreme Court allowed, the administration to proceed, with the mass firings. You hear testimony about the consequences of the freezes and cancellations of foreign aid, the cost to human life that, again, the Supreme Court made possible by blocking the lower court decision that had ordered the administration to pay out its obligations of foreign aid funding. So I think hearings and oversight that underscore the real consequences of the Supreme Court's rulings would definitely be a start of it. I am also waiting for those hearings on ethics and corruption at the Supreme Court that we were promised. And I think those would also be.
We didn't even touch on that.
Right. Yeah.
We have time for, I think, 2 more questions.
Thank you so much. I wondered if you could speak quickly to the major questions doctrine and whether that matters in the current executive environment.
That was on my list, but I didn't get to it. Yeah, you have
so many topics
you have
to
a
talk
whole
about.
chapter.
Yes. So the major questions doctrine, for those in the audience who might not have heard of it, is a rule that the Supreme Court formally announced for the first time in either 2022 or 2023. I can't remember which exact year, but it is a rule for how the Supreme Court interprets statutes that give power to administrative agencies. And what they said is, we will interpret broad general language in these statutes not to confer on agencies the authority to undertake major economic and politically significant action. So basically, it's a thumb on the scale against agencies, and it's a carve-out to statutes that authorize agencies, to engage in, a variety of different regulations. And the Supreme Court applied that doctrine to invalidate several, Democratic administrations' initiatives. They used it to invalidate the Clean Power Plan that the Obama administration, had initially created. They used it to invalidate student debt relief. They used it to invalidate the test or vaccination requirement that the Biden administration had required, during part of the earlier stages of the COVID pandemic. The Supreme Court has yet to deploy this doctrine against a Republican administration. And so naturally, that should make you wonder, well, is the court's assessment, right, of economic or political significance going to be swayed by, ideology and their sense that, well, things are more politically significant when I think they're kind of politically a big deal, or like my intuitions are this would be a massive change to our constitutional system. And I think that remains to be seen. I think there are early signs that at least some Republican justices are not inclined to apply the major questions doctrine to the kinds of regulations that the Trump administration is engaged in. Justice Kavanaugh, for example, has already suggested he doesn't think the major questions doctrine applies to foreign affairs. Well, that, right, just basically rules out applying major questions doctrine to tariffs, to foreign aid freezes, and to potentially other Trump administration actions, that are justified with gesturing to some vague language toward foreign affairs and maybe even national security. And so how does the major questions doctrine factor in or figure in? It's a little bit of a to be determined, but early signs are not encouraging.
We'll take our final question.
I was just wondering, what do you think? Do you think a constitutional convention would be a solution to the current problems we're having, and if so, what kind of outcomes do you think would come from that?
And maybe explain what a constitutional convention is.
Yeah, so a constitutional convention is one of the mechanisms contemplated by the Constitution for amending, the Constitution. And so constitutional conventions, are, I think right now, kind of a project that has been invested in by the right-wing legal movement, in an attempt to remake some parts of the Constitution, that they don't like. And I think part of the concern with using like the convention process right now is it reflects, the Senate malapportionment and the fact that state legislatures are so gerrymandered. And so I don't know that that is like a particularly democratic system right now for engaging in constitutional reform, just because it borrows on, the system of representation that gives each state, right, like equal representation no matter their population, and right, the institution, right, that actually represents the state, the state legislature, is so infected by partisan gerrymandering and potentially racial gerrymandering after this Voting Rights Act case and voter suppression, that I just don't know that that would be the mechanism I would want to use to determine like how to remake and reshape our constitutional system right now until we address those kind of underlying democratic deficits.
All right, well, the book is Lawless by Leah Litman. She'll be signing books briefly out in the courtyard. Please join me in thanking Leah for coming to speak with us today.